In a time on social media when it's full of false narratives and AI-generated content, the truth relies on the help from this channel, loyalty, and betrayal.
It's documentation. Welcome to Loyalty and Betrayal.
Loyalty and Betrayal, what's happening with it, gang? Hey, man, I've been meaning to hit you up. I hope everything is going well with you, for sure.
I forgave Wook, but I can't forgive Randy.
Shout out to fucking Loyalty and Betrayal too. Y'all make sure y'all go over there and subscribe. Cause I'm not gonna let people keep overdoing her paperwork and shit. She the one who created all this. Nigga, if it wasn't for her, honestly, I couldn't have put together. I'm telling you, nigga. Loyalty and Betrayal. Are you watching? Just inbox me yes. Cause you put the keys together, so I'm just gonna say it. I was the first nigga that brought up Ken, man, for a reason. And that's why I hate when certain bloggers, they don't be tapped in for real, man. These niggas be informants, and they be tapped in with other informants. They don't be tapped in the streets, bro. Ken died soon after that paperwork. Zoo died soon after the paperwork. I've been wanting to say this for so long, man. And I'm going to say it because every time I put out a hint, Loyalty and Betrayal put it together. And I can't get mad because I really put it out for anybody. Nigga, I'm telling you, I know for a fact that it was told to me that Jam told on Durk because he felt Durk was going to kill him. The feds.
Seen another video where it's a lady, Loyalty and Betrayal. She went into it and broke it down. She went into all type of stuff to when he first started working and all this stuff, and she don't even get no views and stuff like that, but she most definitely put a motherfucker up on game and showing them what's going on, man. She really do her homework and shit, man. She been dropping content and she be on point with a lot of the shit that she dropped.
Loyalty and Betrayal. Loyalty and Betrayal, he said he fucked your content.
Hey, Loyalty, fuck them niggas. Like, they don't know what they like, you know, you good in my eye. Like, you know, we chop it up every time. You know what I'm saying? You put a nigga on game. You somebody I fuck with. I fuck with you more than a lot of little fans and shit. A lot of fans that I fuck with. I ain't gonna hold. Loyalty a good person.
Yeah. Didn't you read the paperwork or something? Like, I thought that you got the paperwork.
Oh, no, some Loyalty and Betrayal. That's another lady, she got paperwork. She dropped the paperwork and she sent it to me. And I covered it a little bit, but she most definitely is like a paperwork channel. Shout her out, by the way.
Loyalty and Betrayal, honestly, is gonna get her flowers because she does her research. She does what she's supposed to do. She's actually the one that I feel like people take a lot of information from.
They do. And she sent me
and then she don't get the credit.
Yeah, I shout her out as much as I can. But yeah, she most definitely hit me up all the time, make sure I get my story right. So I shout her out for sure.
They say your name, okay. They say your name, okay. Time out, bitch. Clout chase. You don't clout chase. Steady clout chase. Steady clout chase. Steady clout chase. Steady.
You know what I'm saying? It's just the truth out now. Now let it die now.
No, for sure.
You know what I'm talking about? Like, no, I'm saying like the truth out there now. Let it die now. What you gonna get on here and keep on? What we gonna keep on arguing about this shit or what happened? Like, it's over with. I told the story. That's the real story. The story that I told is the story. Look on Lord Truth. Look on Lord Truth. Look on Lord Truth. Look on Trap Lord Ross.
So it was on the Loyalty and Betrayal channel.
If you want to help support this channel, the godmother
of documentation, loyalty, and betrayal. All you gotta do is scan the QR code for the Cash App or the PayPal, and I will receive those funds directly without YouTube getting half of the proceeds. And it would be greatly appreciated. And all funds will go back into making more content for this channel and for y'all's entertainment. Thank you.
Hey. Sorry, I was talking to somebody. Um, how's everybody doing tonight? I think I said hello to everybody in the chat. I was trying to keep up with everybody. Good to see y'all. Good to see y'all. It's been a minute. Been a minute. Shadow, sugar pie, honey bunch. You got an old soul. You know that, Shadow? That's why I thought about that song when I was on your video today. Because you got an old soul. I love me some Shadow story time. I was about to go do some research. Who the hell names themselves hippie? And they look that age that she look. You got to be older than my grandmama to call yourself hippie. That's it. All right, y'all don't know what we're talking about, but that's okay. I got my side conversation. So anyway, how's everybody doing? I hope y'all watched my video, because if you didn't, it's all right. I'm gonna play it again anyway. Glock, I missed you. I missed Glock. Oh my God, how did I miss my Glock? Why could I? You slid in on me. Inglewood Demon, what's up? What's up? What's up? I was giving love away when Glock slid in. Don't tell him. That's what it was. All right. Let me play this short video for y'all. I appreciate it if you watched it on my channel. But we're going to play it for y'all anyway, because it's going to play right into this live. Just is what it is. And yes, I'm being a petty bitch. You want to be an emotional bitch in my DM? I can be a petty bitch. So here we go. Now let's listen to what this blogger's conclusion on these documents actually was.
So there's that fact. I don't know what the feds are planning, but I can tell you this. Whatever they're working on, they're going to have to bring hellfire. Nobody's going home today. Nobody's going home until like 12 o'clock today. That'd be impossible. What they just accused the feds of doing, which I accuse them of doing all the time, is lying. Flat out. I don't believe that the government has what they believe they have. Everybody else who's involved in the case, I believe they got some on them. When it comes to Lil Durk, it just seemed to me, y'all can disagree, y'all guilty by association. But we'll see, man.
Now I want y'all to look at this right here. It says 469 OTF Durk'S. You can see here, I acquired the document at 1:31 this afternoon. That was 469. This is document 470 from OTF, the government. I acquired it at 6:14 this evening. That means it was already put out, it was already filed, and then the filing had to go to Pacer, and it had to get uploaded to where it's even available to us. So I don't know where he's coming off that everybody's going to be there till midnight. It's impossible. But let's keep listening. Now, I want y'all to watch how this blogger doesn't even read all the documents and misses the entire juicy dirt alert. Check it out.
It is true that the Speedy Trial Act contains an exclusion for a period of time when defendant is joined for trial with the co-defendant as to whom the time of trial has not run and no motion for severance has been granted. We're going to leave it right there because it's prejudice.
I want to see if any of y'all catch the juicy dirt alert.
True when they say that shit. They just go on. Now, to reiterate that none of the stuff that was given before actually is new, and it doesn't actually bury Lil Durk. The government has endangered Mr. Banks' constitutional rights with its lack.
Now, I recently heard this man refer to himself as the hood lawyer. That means that you investigate, you do your research, and you have knowledge of documentation. I'm fixing to prove to y'all how much he lacks. Listen to him as he reads this section right here. When he gets to the end right here, you see that is a comma. Check it out.
Putting aside the timing of the interviews, though the substance of these 302s is not groundbreaking or revelatory, hardly do establish the PW3's personal knowledge of the Chicago murder as the government's representation to the court on July 1st. PW3 has no firsthand knowledge of the Chicago murder at all. His recent statements add nothing to the government's investigation.
Do y'all see how he just read straight through that? This is a comma. This is an indentation with footnote number 5. This is all redacted information. This is redacted information. This is all redacted information. He has no clue. That's what it is. But you're the hood lawyer that's going to give them all the information as it's made available. No, you didn't. So, for those of y'all out there that want the full story of all the documentation that was dropped today and all the information in the documentation that was dropped today, have your notification bell set because I'm going to go live and give you all the information, including the juicy dirt alerts. I'm not going to pick and choose what information I want to tell the people, or I want certain people in the documentation to look good. No matter what my personal feelings are towards anybody that I'm doing documentation about, I still give you all the information and you get to still make up your own mind. I'm not pushing an agenda. All right. Pull that down to me. I'm trying to get to y'all's comments. On the 14th, yes. And there was several documents that was filed today. Matter of fact, when City Nash made his video about the government being there until midnight tonight, the government's response was already posted on Pacer at that time. But see, he doesn't go to Pacer. He goes through third party imaginary manager of Durk off of Twitter or wherever to get his documentation. And so he's at his beck and call, that type of thing. So anyway, if y'all are ready, we're going to get into this. Now, hold on. I got to mute this. Somebody left me a message. All right. Um, let me pull up. Hold on, yeah. I gotta pull my YouTube back up. They were DMing me about the Nolan case because my sister has some information. She's actually been over there. She knows a lot of stuff from there. And one of the messages was from her. I think she's going to be bringing some barbecue over here in a little bit. She's got the littles with her. All right, let me set the phone there. I hope Zoo didn't wear a wire. I've not had any knowledge of Zoo wearing a wire. I will say I'm on the fence whether or not he said anything when he got older, because he had matured mentally and physically and had kind of pulled away from the guys, and he was trying to go on a better path in life shortly before he was taken out. But I do know for a fact Luna wore one, but now he's tried to take back everything that he said, and he doesn't want to take the stand on anything because of him committing that homicide, and they charged him with that homicide. So now he doesn't want to cooperate anymore, so I don't know how that's going to work out. But what they got on wire was Durk admitting that he was purchasing guns in Atlanta and sending them back to Chicago. And I've been telling y'all that since I found that out back in 2023. So that's how I knew that there was going to be an OTF RICO. But that's been told a million times. Folks just don't believe me. And everything I tell, it's still playing out. It's still playing out. It's still playing out. What I used to say, D-Love, don't believe me, just watch. Divine, what's up? Did you read that juicy dirt alert? I sent her copies of the paperwork. She likes to keep up to date on it, too. All right. Let's see here. I was teaching nephew Samuel how to do StreamYard today because he's supposed to get a computer for his birthday. And him and Chloe subscribed to my channel today. And Chloe says, I'm going to watch your lives, Aunt Cassie. You better not. You better not. Why? You talk crazy? Anyway, to us, what's the difference? Okay, well, that's true. But my content is not for children, even though I talk to them the same way I talk on here. Told you, D-Love, that girl's a handful. That girl is a handful. All right. Let me get this screen share set up. Now, I think I'm going to do this out of order. Just basically because it is so lengthy. So, we're going to start with the last document that was dropped, which was considered they want some stuff sealed up. Okay? And the reason why I'm reading this to you backwards is because, get this on here big for y'all, is because I want y'all to have this knowledge as I read the first document that came out today. This says the government's unopposed ex parte application for order sealing documents, memorandum of points, and authorities declaration of Daniel Weiner. Now comes the United States. That's us, or not us, but that's them. Okay. They were asking for an order directing that the government exhibits 2, 3, and 4 to its supplement to this opposition to defendant bank's motion to sever counts, or in the alternative to dismiss the third superseding indictment on a speedy trial grounds, be kept under seal until further order of the court. That was done today. You can see that right there. Okay. Now, the memorandum of points, it says the plaintiff, United States of America, requests that the court seal the government's exhibits 2, 3, and 4 to the supplement of the opposition to defendant bank's motion to sever counts, or in the alternative to dismiss the third superseding indictment. The court has inherited supervisory authority to seal documents in appropriate circumstances. Here, for the reasons described in the attached declaration, sealing of these documents is necessary to protect personal identification information of third parties and/or sensitive information related to witnesses cooperating with the government. This was done today. Okay. Now here's his declaration. He says he's Assistant United States Attorney, blah, blah, blah. The reason he's given of why he wants them to be sealed is that the above described documents discuss and/or contain personal identifying information of third parties and/or identifying information of witnesses who participated in the government's investigation, who may testify at trial, and/or whose safety or whose family safety may be endangered by disclosure of identification information. If y'all will remember, at the very beginning of this, Durk was accused of intimidating witnesses, family members of witnesses. It says sealing of the documents is therefore desirable because the government believes that the public's disclosure of such information may endanger the witness and/or their family safety and could cause others to attempt to intimidate the witnesses and/or their family, or otherwise dissuade the witnesses from cooperating with the government. Accordingly, the government requests that the documents be kept under seal until further order of the court. On July the 13th, 2026, counsel for defendant banks advised the government via email on that they had no objection to the government's request. As of this time of filing, no other defense counsel noted an objection to the government's request. And he declares under penalty. Okay, there you go. That's that one. Now, let's see. Do I want to read this one first? Might as well. Might as well. This is 470, excuse me. This was filed today. This is the response to the 469 that Durk'S attorney filed. This is a supplement to the government's opposition to defendant bank's motion to sever counts, or in the alternative, dismiss the third superseding indictment on a speedy trial, and exhibits 2, 3, and 4. Okay, that's just like the introduction there. The government files a supplement to correct certain factual assertions in defendant bank's reply and to provide a more fulsome record for the court. And I'm reading this way because if you've already watched Setting Ashes, hop, skip, and cherry pick the information, this will be more interesting to you. But like I said, I want y'all to have this information when we go over the other one, because the other one's a lot longer. It says, first, defendant banks incorrectly states that a forensic examination report of co-conspirator number 4's iCloud was first produced on July the 8th of 2026. Attached is Exhibit 2, is the government's discovery letter documenting the production on December the 10th of 2025. So this was last year before Christmas, of the entire forensic image of co-conspirator 4's iCloud, along with over 35 other seized devices and/or accounts. On December the 10th of 2025, there was a discovery letter and FBI 302 documenting the production. Notably, the government made this production to accommodate a request made by defense counsel to examine the full image of all the digital devices and accounts seized by the government. United States Assistant Office cover letter noting that the production was made at the defendant's request. To the extent the defendant believes the subsequent June reproduction of the material, which means they redid it, contained in the iCloud account a plethora of Brady Gigolo. Brady Gigolo is when they're going to put something or somebody on the stand for the government, the defense has to be able to vet them. They have to be able to go and see how credible, whether it's information or whether it's a person, how credible this stuff is. That's what Brady Gigolo is. It says that material was available to defendants in December of 2025. Secondly, the government did not shirk its responsibilities under the pretrial schedule. Following the return of the third superseding indictment on June the 3rd, the government sent numerous communications to defense counsel seeking clarity about the trial date and the pretrial deadlines to provide a more fulsome record to the courts. The government attaches as Exhibit 3 the remainder of the email thread attached as Exhibit K to defendant Banks' filing. So what they're saying here is Drew Finley tried to show part of an email and claim that the government was saying one thing. And so now the government has come back and showed the full email to show that Drew Finley is full of shit. That he's trying to pull the okie doke over on the courts. Exhibit 3, documents that the government circulated a proposed stipulation modifying the pretrial briefing schedule and asked for authorization for e-signature, to which only counsel for defendant Houston responded. In other words, Houston, remember he wanted to set his off because he had just got new attorneys. Nobody else was complaining about any of the scheduling and nothing like that. Moreover, attached as Exhibit 4 is an email thread in which the government solicited defense counsel's position on a continuance. In other words, they asked the defense, are they needing a continuance? Are they wanting one? What is y'all situation? In exchange, the government noted that its trial exhibit list and motions in limine were a function of which defendants and which charge would be proceeding to trial on August the 20th. In response, defendant Banks' counsel responded that they were prepared for an August 20th trial as of now, and counsel for defendants Wilson and Lindsay represented that they would be prepared for an August 20th trial if the court were to grant one or more of the pending severance motions. So they put a clause on it. So they're, in essence, they're saying, but since y'all won't sever, no, we're not going to be ready on August the 20th. Third, contrary to defendant Banks' claim that his multiple explicit past assertions of his speedy trial acts are clear from the record, the defendant, including Banks, caused the prior continuances. Defendant Banks requested the initial November 11-month continuance in October of 2025, and he took other steps to delay this trial. For example, in November of 2025, Banks filed his motion to disqualify all the Central District judges and the United States Attorney's Office, which explicitly asked the court to vacate the scheduling order, including the January trial date and calendared motions that were set for hearings November the 18th of 2025. After the court entered a minute order the following day, making it clear that it would not stay the proceedings, defendant Banks filed a written objection asking again to stay the proceedings and vacate all the dates. When the court declined to stay proceedings, defendant Houston, Wilson, Lindsay requesting a trial continuance because the court would not vacate the scheduling order. So again, it's the defense's side that's been asking for the postponement. Finally, As set forth in the government's opposition, defendant Banks has failed to justify the extraordinary relief he is requesting, while defendant Banks' reply asserts that a further continuance will be lengthy based on conflicts of other defense counsel. He does not indicate how much time he will request, if any, should the court deny either of the pending motions. And as you can see, it's under seal, so we cannot see that stuff. Let me see where y'all are at here. It's going to be a messy, a hot mess. That's a fact. That's a fact. Okay. Now, this is the one that said he was reading from, and I don't know who else read from it today. I'm sure it got posted on Reddit or whatever. I don't know what was said. I was at work twice today, so I ain't had time to go looking. But this is coming from Durk'S attorneys. You can see their names listed here on the side. It says, a reply in support of his motion to sever counts or in the alternative to dismiss on the speedy trial. Now he keeps filing this. Does he not realize, or does he think the judge is stupid and not realize that's causing things to get delayed? Because now we got to have a hearing on this, which is tomorrow. Every time you have a hearing on something, you're taking a chance on knocking the trial date. So we have the whole table of contents. Now this is Drew Finley speaking, okay? Exactly, D-Love. What did I tell you? When I read the document, this document here, and I went back to work, and I messaged you and I said, all it is Drew Finley whining and crying. He doesn't really specifically come with anything. He's just whining and crying. And that's what these 19 pages are going to be. You're correct, Savage. It's Buna, not Booney Mo. Although I do think Booney Mo did something, because how are you going to get 2 bricks changed up to less than 10 grams? That's just my opinion and my experience. I don't have no proof of that. I've been said I didn't have no proof of it, but that's just one of them things that make you say, Let me see. Hold on, y'all. Oh, they're playing. Okay. The Littles are over at Sisters, which is a block away. Their mama's at work. Their sister's taking care of her father. I guess they're back in Chicago now. So this is where the village kicks in to help take care of the kids. She got them to walk over to her house for supper tonight, and she's letting everybody know what they're doing, where they're at, and when they'll be walking back over here. They're supposed to let me know when they get back over here. So that's why you're going to hear my phone going off. They stay right next door to me, so I think they came over here like 6 times today, irritating me. Okay, it says whether purposeful dilatory tactic or a lack of diligence or both, the government's action in this case have endangered Mr. Banks' speedy trial rights. Those actions include bringing last-minute, wide-ranging charges that were equally available months ago. Like I said, this is just a boo-hoo crybaby shit. Because the thing is, this is my outlook. Whether it was Durk, whether it's Butter, whether it's Duck, whether it's Von, I don't care. If you did the crimes, and the statute of limitations allows them, I had the shit done to me. Statute of limitations was 2 years. Less than 2 months before the 2-year mark, they pulled the carpet out from underneath me. I was mad as fuck, yes. But guess what? That's what the law allows. And this is what he's complaining about because they had it available months ago, blah, 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 blah. Well, some of it was available, some of it was not available. But either way, they're allowed X amount of time. Get over it. You've been an attorney long enough, you should know these things. I'm reading y'all's comments. Okay. It says they included massive belated discovery productions related to those new charges. They include the government's refusal to abide by the pretrial schedule in which it was previously committed. In its opposition, it's got footnote number 1. Okay. Doesn't really say nothing important. The government does not and cannot provide any good explanation for why it has intentionally impeded Mr. Banks' impeding trial date. Instead, it scatters a consolation of vague excuses, but fails to connect the dots. See why I wanted to read y'all that other stuff first? What material new developments explained the third superseding delaying timing? Why is the government just now turning over volumes of discovery that it has in its possession for months? I'm remembering the thumbnail says, government's hiding stuff. No, they weren't hiding it. They spit out the dates on those other documents. Apparently not. The government is banking on a continuance. And if they are, they're entitled to it. Oh, well. Okay, play criminal games, get criminal charges. It is what it is. Behaving as if Mr. Banks has waived his speedy trial rights and the August 20th trial date is already off the calendar. Not so. It is unfair, dilatory tactics and our transparent attempt to delay justice. But for Mr. Banks, who remains incarcerated and eager to go to trial, justice delayed, injustice denied. Drew, you're acting like a drama queen. It just is what it is. The court should restore the fairness the government attempts to strip from Mr. Banks and sever the Los Angeles counts for an August 20th trial. Why are you so scared of the Chicago and Atlanta cases being thrown in here? Your client's supposed to be innocent. The government's actions have endangered the trial date. It is beyond. Let me just say this real quick. This just popped in my head. I would want them all together. Because if you find me guilty of them all together, whatever punishment I get, the judge, 9 times out of 10, is going to run the punishment on top of each other. They're not going to run it back to back. If you sever that shit, there's a 50-50 shot that I'm going to be found guilty, and that other court over there can add it on to the back end of whatever I got to do over here. And if you put it all together, you got the double jeopardy. You can't recharge me or repunish me in another courthouse. All right, it says the government sought a hefty superseding indictment just 11 weeks before trial. It has withheld discovery, for example. It refused to comply with Mr. Banks' October 17th, 2025 request for the Chicago case file, and then misrepresented it to the court that it had turned it over when it had not. Large portions of that Chicago discovery, nearly 10,000 pages, were produced as recently as Monday, July the 6th, just a month and a half before the scheduled trial date. Another large production occurred on May 29th, but with errors that were not fixed until June the 26th. This is despite the fact that the government has always had access to it. Further endangering the trial date, the government shirks its responsibilities under the pretrial schedule to which it previously agreed. For example, after extracting a promise from all the defendants that they would not seek to continue the current August 20th trial date any further, the government committed to producing a draft exhibit and witness list 10 days in advance of the motion in limine deadline. So you got it before the deadline. What you crying about? This the parties recognized was necessary so that the defendants could intelligently file motions tailored to the true evidentiary issues at trial. But once the government filed the third superseding, it behaved as if the August 20th trial date was automatically off the calendar. All dates keyed to it vacated. The initial June 19th witness exhibit list disclosure deadline, keyed to June 29th motion deadline, came and went. After agreeing over email to move the motion in limine date to July the 6th, a date which triggered a June 26th exhibit trial list disclosure deadline, the government again failed to follow through. And finally, after the court set an August 13th motion in limine date, Mr. Banks' defense counsel reached out in an attempt to confirm the government's intentions to comply with an exhibit and witness disclosure deadline. Well, you just said up here that they gave it to you 10 days in advance, crybaby. To set a motion in limine schedule and to find time to meet and confer. Example K, as the date of this filing, the government has failed to meaningfully respond. It remains unclear whether it will provide a draft exhibit and witness list by tomorrow, July the 11th. So this was actually done up on July the 10th, but it just got filed today on the 13th with PACER or with the courts. Whether it will meet and confer with the defense counsel regarding motions and whether it will be filed its own motions on the proposed date of July the 21st. They ain't as hot as they used to be. Pretrial schedules are designed to keep a trial date on track, yet its behavior demonstrates, since it filed the third superseding so late, that the government is not interested in keeping this trial date on track. Quite the contrary, it seems to consider a trial continuance given. Now, I'll say this. You take the 11 months that Durk postponed the trial, we're going to throw another month on there for all the bull crap where he wanted everybody kicked off the case, all the judges, all the prosecutions, they don't even want the courthouse. We want to move this to another state, the whole 9 yards. So that whole year that Durk delayed everything, if he would not have done that, then we probably would have saw this third superseding indictment a year ago, because I'm sure that the government had this planned, like everybody says. Okay, so then we would have saw this a year ago instead of seeing it now. And then what would you be crying? Or at least maybe you'd have some kind of excuse to cry. I don't know. The government's bizarre overconfidence in the vetability of another continuance is in stark contrast to its obligations under the law. The Constitution imposes upon it a duty of diligence to bring a defendant to trial. For that reason, the government bears the burden of justifying a pretrial delay. In accordance with this, the government's opposition correctly recognizes both implicitly and explicitly the particular importance of a second marker factor, the reason for the delay. They're just quoting some laws here. Let's see. Which basically says they got to have a reasonable reason for not being diligent. The government fails in its opposition or elsewhere to carry its burden of showing diligence in bringing Mr. Banks to trial, a duty that includes abstaining from neglectly or purposely imperiling the current trial date. I need to drink my Big Red. Lord have mercy. In its 22-page opposition, the government waxes on about many things: the volume of discovery, what evidence exists to support new charges, the Chicago case, even Mr. Banks' flights to Dubai. Hoping that the court won't notice that none of these things are a valid reason for the timing of the third superseding indictment, for its failure to timely provide discovery or abide by pretrial schedule. We consider and debunk each category of vague excuses in turn. The government's opposition seems to argue that material developments in the Chicago case caused the delayed timing of the third superseding. It reads, defendants' arguments that the government took the Chicago incident off the table when it withdrew its motion to admit it under Rule 404B freezes past material developments in that case, which contributed to the government's decision to include it as direct evidence, but not under the 404B in the third superseding indictment. But there is no new material developments which have occurred since the material developments to which it points are not material and are not new developments. Okay. Obviously there's new developments because we didn't have the statements. I'm reading y'all's comments. Okay. The guilty pleas. The government relies heavily both in its opposition and its oral representations to the court on July the 1st on the recent guilty pleas of Mr. Montgomery Wilson and Mr. Powell in their prosecution of the Chicago incident in the Northern District of Illinois, in that both defendants' plea agreements and colleagues that they admit to committing the charged murder in exchange for pay, even if those admissions represent some sort of significant development in that case, which is debatable since the defendants have been accused of committing a murder for pay since 2023. Now, I noticed when I read that how Drew purposely did not put murder for hire, because this is a murder for hire case, so he doesn't want to have another murder for hire case being attached to this, so he changed up the wording and saying murder for pay. It's just a mind game, play of the words. It's something that Drew's been doing all along. They have absolutely no bearing on Mr. Banks' prosecution or trial. First, the defendants there did not say either in their plea agreements or at a change of plea who paid them in exchange for the murder. In order to be pertinent to Mr. Banks' case, including, as the government now argues, ex post facto to bolster the reliability of Mr. Montgomery Wilson's Perkins recording, the statements would have to be about Mr. Banks. They are not. Second, now, this is the way I described it to Divine when I was talking to her earlier. The way that they play word games. This part right here where he says that it would have to be about Banks. We don't know what was said because that hasn't been made available to the public yet. But if they said the guys from OTF or the leader or anything like that, if they gave him a different nickname and he didn't specifically say Durk'S Banks, that's the way that Drew Finley is playing word games. It says, secondly, any statement in a plea agreement or a change of plea would be inadmissible in any other criminal prosecution under the Sixth Amendment's Confrontation Clause. And finally, there's no indication that either Mr. Montgomery Wilson or Powell is cooperating with the government to provide additional information or admissible in court testimony. The guilty pleas are a red herring, neither material nor true developments that would explain the third superseding timing. Other alleged Chicago evidence. Next, the government points to alleged evidence from regarding the Chicago incident that has been available to them all along. Text messages, photographs, video files, alleged jailhouse confessions. These offerings are not developments that would warrant a third superseding timing just 3 months before trial. On the contrary, they are part of the case file in the Northern District of Illinois prosecution. These prosecutors have long had access to that file, and at least since October of 2025, having denied Mr. Banks' defense team the same access. It says October 17th, they requested the file, and then on Halloween, the government refused it. to provide it. In fact, much of that file was just produced to the defense team on Monday, July the 6th of 2025. If the government had been acting diligently, it would have evaluated that case file promptly, made reasonably timed charging decisions based upon the review, and turned the case file over to the defense either when it was requested or as soon as it became apparent that it could possibly or potentially be an issue in Mr. Banks' case. The government's handling of the Chicago incident is not diligent investigation. On the contrary, it is an example of the pervasive hide the ball tactics. Again, if it's within the time frame, nobody gets to pick and choose that. Yeah, it sucks. Being the defendant, it sucks. Just like with statutes of limitations. They can go all the way up to the 11 o'clock hour on the last night and do whatever it is that they want to do. And it sucks. But it's still what the law is. Now, Protective Witness 2 and Protective Witness 3, long-running cooperation. Yet little to aid in the Vicar charges. So this tells me that Durk and them know who these people are. Because they know whatever information about them. So they have to know who they are. The government also attempts to blame the delay in the third superseding on its acquisition of new material information from cooperators with first-hand knowledge of the Chicago murder and the Atlanta shooting. At the July 1st hearing on Mr. Wilson's motion to sever counts for bail, Mr. Wilson's counsel pointed out the unfairness in the third superseding timing. The response the government first proffered the Chicago guilty pleas discussed above, assuring the court that it moved swiftly to indict after those April and May change of pleas, implying the guilty pleas were dispositive in the government's decision to bring the Vicar charges. Later in that hearing, after the admissibility of the guilty pleas in this trial was correctly called into question, government counsel did not counter that they matter because they bolster the Perkins statement in admissibility. Instead, counsel offered a second separate reason for third superseding delay, explaining, again, we dispute Mr. Harburg's claim that theirs is just simply nothing new. What the defendants will see in discovery, if they haven't already, there are cooperating witnesses that we will, with personal knowledge of both of those events. On Monday, July the 6th, the government produced more than 20,000 pages of discovery, the vast majority of which they've had in their possession for many months, which included a 302 in which the government apparently refers to number 2 and number 3. Now, again, I can't do this. All of this blank area, and you see this period right here? This is all redacted. This is something that they're saying that they do not want the public to know. Neither of the 302s justify the third superseding delayed timing. And they have all this blank. Well, it's not blank, it's a white redaction. If the government has been acting diligently to respect Mr. Banks' speedy trial rights, a diligence that includes avoiding unnecessarily delaying charges that carry the potential to dislodge a trial date, it could and would have asked its cooperators about this supposed gang-related racketeering activities from the start. The government wants the court to believe that it never thought to inquire about these specific incidences until April 21st for number 3 and May 21st for number 2, despite previously having notice of them on the Federal Rules of Evidence 404B evidence. If it can be believed, that is not diligent investigation and does not justify the government's poor timing charging decision. Again, We're 11 pages into 19 pages, and all they're doing is complaining about the timestamp of the third superseding indictment. That's it. Putting aside the timing of the interviews through the substance of the 302s in the not groundbreaking or relatively hardly do that they establish number three's personal knowledge of the Chicago murder as the government's representation to court on July the 1st. According to the 302, all this is blank here, and this right here. Footnote number 5 says a person's expectation of the receipt of a benefit in exchange for committing a murder is insufficient to satisfy the statute, which requires bargain for consideration and a payer's intent to pay someone in exchange for murder. Number 3 has no first-hand knowledge of the Chicago murder at all. His recent statements add nothing to the government's investigation. And then there's another sentence with a period here, and another sentence, at least one sentence here, if not two. Now, Divine, it just popped in my head. Fred and Benji. I don't know. I'm thinking so. So, whatever this sentence says here, it starts off here, halfway through whatever it was saying. It says, established that he had personal knowledge. It's got footnote number 6. Personal knowledge requires that a witness who testifies to a fact has actual observed the fact. Okay. Of an attempted murder in Atlanta. Then we have all this redacted again. Now, the attempted murder in Atlanta would be that gas station shooting or whatever it was at, right? They better not all pre-bargain because I want to know the answers, damn it. The government's attempt to create the impression that the volume of data it has collected and reviewed somehow created the delay in the filing of the new Vicar charges. It cites to the fact that its investigation involved a robust legal process and the reviewing of voluminous digital records with 59 devices and accounts, 38 after the arrest. Later, it recounts, following the arrest, the government continued to investigate uncharged co-conspirators and other criminality links to the bank's gang enterprise, including through proffered multiple cooperating co-conspirators and by seeking additional warrants to seize for and seize evidence related to the RICO and Vicar. As the government continued its investigation, including its review of voluminous electronic records, it found significant gang enterprise evidence. That's the government at various points after Mr. Banks' arrest collected what they characterize as enterprise evidence is irrelevant to this motion unless the timing of that collection and review justifies the delay here. In other words, the question is not whether there is evidence to justify the third superseding. The question is whether the timing of the third superseding is excused as a product of diligent government investigation. In that regard, the government's narrative falls short and seems to purposely obscure the timing of their efforts. In most places, it describes evidence that we know has been in the government's possession for a year or more. See footnote number 7. For example, the vast majority of the phones and other devices that were seized were done so at or even before the time of the arrest in October of 2024. To disguise this reality, the government's narrative of its evidence collection largely lacks dates. I hear the kids coming in. This timeline of events that admit. Oh, it's you? I thought you were the kids. It's not. You gonna kill me? Is it hot? Okay. Okay. Lily! You didn't get the sunnies?
So I had used the whole
Oh.
I used the whole can. I figured they were gonna finish it off and give you a little bit left. And
They act like they're starving all the time, and then all of a sudden you try to feed them, and then they nibble at it. So they went home. What time Kelly get home? I didn't ask them. So that's only in 2 hours. So yeah. Chloe said she's gonna watch my lives. I told her she better not. It's not intended for kids. Yeah. All right. Thanks. Okay. She brought me a thing of food. And I was gonna give it to the dog Lily. Okay, let's see. Where did we leave off? Okay, timeline of events that amidst the government's receiving and reviewed evidence supporting the third superseding. Narrative of evidence collected with a few specific dates of collection and review. In the few places where the opposition does recount dates, those dates do not account for the third superseding's 11th hour timing. It's not an 11th hour, it was almost 3 months. For example, the government recounts how in February of 2025, it sought and obtained a rollback warrant to search enterprise evidence. That was co-conspirator 3 and 4. That was 15 months ago, the third superseding, before the third superseding. It also recounts how in September 25, it obtained a warrant to search bank's social media account and found 2 contraband devices apparently smuggled into the MDC. That was 9 months before the third superseding. These dates do not bolster the government's case for its own diligence. I'm reading out comments here real quick. Okay. Nor has the government been diligent in producing the voluminous discovery to the defense. For example, on June the 8th of this year, the government produced a large amount of evidence that included a forensic examination report of the alleged co-conspirator 4's iCloud. That report, which is 7,307 pages long and contained a plethora of Brady and Gigolo, was generated on December the 15th of 2025. Oh, I forgot to ask sister. I'll call her and ask her. Nearly 6 months before it was produced in Discovery. This is but one example of many. For the government to carry its burden to show its diligence in bringing Mr. Banks to trial, it cannot just point to the volume of evidence collected. It must explain what key evidence was only discovered very late in the day, despite its exercise of reasonable investigative diligence. It does not do so. They don't gotta explain shit to you if they're, as long as they're within the time frame. The government contends to the extent defendants believe the investigation could have proceeded faster, defendants' own conduct significantly contributed to the investigation's complexity. It lists various ways that Banks had allegedly attempted to evade arrest or conviction, including by using coded language, instructing others to delete text, attempting to intimidate witnesses, and even by attempting to fly to Dubai the day of his arrest. What does a flight to Dubai nearly 2 years ago have to do with the last-minute timing of a third superseding indictment, or with the government's delays in producing discovery in its possession? Wah, wah, wah. The same question remains unanswered as to the use of coded language, which the government has always claimed to decipher with its help of its longtime cooperators. The instruction to delete texts, which were clearly not followed, or alleged attempts to intimidate witnesses. The coded language, for example, was difficult to understand up until last month when the government brought sweeping new charges. Unless the government can tie any of these new allegations to its delay, they are immaterial distractions. None of the government's vagueness excuses stand up to scrutiny. On the contrary, the timing of the government's decisions were used to gain tactical advantage in It took Chicago off the table as proposed in 404B evidence in order to defeat Mr. Wilson's severance motion. Banks was also induced to put down his pencil as to that issue, so to speak. The government then reintroduced it at the last moment when Mr. Banks had been deprived of the ability to prepare his defense regarding that very complex and circumstantial case in the interim. The government plays coy when it pretends not to understand what, if any, delay is relevant to the Barker analysis, particularly because Mr. Banks has not asserted what length of delay would be required should the court deny his motions. As the government well knows, it has consistently been difficult to find trial dates in this case that work for all the lawyers involved. If no severance is granted and the court continues its trial date, the earliest that Mr. Wilson's counsel, for example, could try this case would be August of 2027. And that is just one of the 11 lawyers whose schedules the courts would potentially have to consider in order to set a new trial date. Mr. Banks would thus be forced to wait at least another whole year for his trial. Well, at least he'll have some good defense at that point. In the absence, this is if they don't sever. Despite the repeated and vigorous assertions of the speedy trial rights, if the government actions were succeeded in pushing out the current trial date, the future delay will be lengthy indeed. Compounding the general scheduling conflicts, the trials with multi-defendants and many lawyers commonly face, this court is acutely aware that defendant Houston was recently appointed new counsel who have indicated that they need substantial time to review the voluminous discovery. The government does not indicate that it has conferred with his counsel to determine what the actual length of delay is anticipated to be. Is it a few months, a year, or more? An answer to those questions must be satisfactory answered by the government, but instead, in its opposition, the government ignores this issue and pretends that the delay is only 21 months. That is a falsehood. It cannot go unmentioned that the government was initially intimately involved in the litigation that led to the necessity for Mr. Houston to get new counsel. This again is a delay that cannot be attributed to Mr. Banks and lays squarely on the feet of the government. All right, I was trying to read that again to myself, make sure I understood it. It is this likely future delay combined with the past delays that are problematic on speedy trial grounds. The government's attempts to isolate past periods of pre-trial delay in order to defeat them failed. It is true that the Speedy Trial Act contains an exclusion for a period of time when the defendant is joined for trial with a co-defendant as to whom the time of the trial has not run and no motion for severance has been granted. That exclusion only applies, however, to be a reasonable period of delay. As the courts have recognized, there comes a time when the cumulative amount of co-defendants related excusable time becomes unreasonable and thus unconstitutional. A delay that might seem unreasonable in the abstract or in its isolation can be rendered unreasonably by the cumulative effect of the delays. What? Oh, sister said she checked the house, make sure there was no strangers. Okay, you ain't got to tell all of us all that. You did your thing. And so even if the court believes that the delay between October of 25 and August of 26 was excusable, Banks believes that it was not. It becomes unreasonable when considered in conjunction with the delay that it likely happened in the future, that delays fall at the feet of the government alone and not the co-defendants. When the government fails to demonstrate its own diligence in bringing a defendant to trial, prejudice is presumed. This is just quoting some more laws here. It says, because the government failed to act with diligence, Mr. Banks need not demonstrate any concrete prejudice. Even if prejudice were not presumed, through serious prejudice has already demonstrably unfolded since October 25 trial date that Mr. Banks demanded. If Mr. Banks had gone to trial in October as it was demanded, it would have only been the Los Angeles counts. With that evidence the government had gathered then, to the extent that the government believes it has, since that date, acquired additional witnesses or evidence against Mr. Banks that it would not have had back in October of 25. Mr. Banks has been prejudiced by the delay. That tells me y'all are scared they're going to find out some more shit if anything else gets delayed. That's what that sounds like to me. I'm just saying. Yeah, word salad. There you go. Brother, this is the part that Seti Nash just skipped right over. Y'all ready for this juicy dirt alert? Brother, in the words of the Supreme Court, if a witness die or disappear during a delay, the prejudice is obvious. Here, co-conspirator 6 passed away on October 26, 2025, after what should have been the October 14th start of Mr. Banks' trial. According to the government, co-conspirator 6 is a central figure in both Atlanta shooting incidents and Blackshear, Georgia shooting, and these new allegations surrounding an alleged car theft ring. So these are some new allegations that we have not even heard about. See what happens when you skip over stuff, bloggers? It says, in fact, according to the 302 of Detective Witness 2 produced just this past Monday, co-conspirator 6 alleged after the fact hearsay statements provided the bulk of Detective Witness 2's personal knowledge of the Atlanta incident. But since he is now deceased, Mr. Banks can no longer interview him or call him to the stand. The government's opposition ignores this completely. The defense has been hindered by the passage of time, particularly given the nature of charges, which are most likely proved to or rebutted through testimonial evidence. Importantly, through what prejudice will unfold during the period of any future delay remains to be seen. That is a question that the parties could be asking the Ninth Circuit to evaluate in 3 years' time if this trial date is pushed back. What we know at this point is that the government is currently attempting to take practical advantage of the continuance upon which it relies. For example, the government made such of a recent guilty pleas of Montgomery, Wilson, and Powell upon information and belief as recently as May and June. The government contacted their lawyers attempting to solicit their cooperation in the case against Banks. It bears emphasizing the government did not reach out to these lawyers a year or 6 months ago, as it should have in the exercise of good faith investigative diligence. Instead, it did so within days of their presentation to the grand jury in the third superseding. If August 2026 trial is continued to 27, and if either of these people or anyone else for that matter decide to take the government up on its recent offer to cooperate, that is a massive tactical advantage that the government will have acquired because of a delay that it caused. Only time will tell all the ways that the government will use the delay to the detriment of Mr. Banks' defense. It clearly intends to do so in any way it can. It says, okay, that's a case reference. Mr. Banks' multiple explicit past assertions of a speedy trial rights are clear from the record and not to be rehashed here. However, the government's opposition seems to suggest that Banks has made the decision to ask for further continuance. To clarify, at this time, Mr. Banks agreed to continued this August 20th trial date. He continues to assert his speedy trial rights at this time. The government has endangered Mr. Banks' constitutional rights with its lack of diligence and its purposeful choice. For the reasons set forth above and in his motion, Mr. Banks respectfully requests that the court sever the Los Angeles counts from the Vicar counts so that he may receive the trial that he has been preparing for and constantly demanding. Well, let's see. Y'all remember when I pointed out how nobody pays attention to the document's numbers? Like tonight, we read 469, 470, 471. Okay. Let me see. All right, we're going to go backwards. We're going to just read these real quick. Let's see. 69, 67, 65, 64. All right, let me go forwards for y'all so I don't confuse y'all. 460, 461, 462. We skipped 463. We got a 464, 465. We skipped a 466. We got a 67. We don't have a 68. So right there, you've got 1, 2, 3, 4 documents out of the last 10 documents that are missing, that they have not made available to the public. Okay? What does that mean, Godmother? That means that's information we don't have. Like, what is this new thing with the car ring, stolen car ring? How did they say it? Allegations surrounding an alleged car theft ring. There we go. Bah. That BAYZOO had something to do with. So these are new, or these are other incidences that are being brought up. What does that mean to the case? Well, let's go back to the Oblockians. They were being charged in Durk'S homicide. What they brought up, though, was Del Fisher, K.I., there's a couple more. Let me think. T-Roy's. Just different cases, different incidences that took place to show the proof of whatever it was that they were trying to show the proof of. Same thing here. Apparently, they're in this case here, they're trying to show proof of an enterprise. Now, I think they have more than enough evidence. I don't know. You know what? Let me see here. What is the actual definition? A kingpin is the central, essential, or leading figure in an organization, scheme, or operation. Well, they've already done that then. Because that's why they brought it in as a Vicar. They've taken all the RICO incidences, and when you have that many RICO incidences, especially under the same umbrella, that's why they get to throw it up as a Vicar. That's why O Block trial ain't started. What do you mean the O Block trial ain't started? It's finished. They were convicted. They're just waiting for the sentencing. We ate. Not trying to kill you. Sister try to kill me. Oh, you're trying to say that they're gonna try to connect it. Um if you look at the definitions, okay? Like, I don't even know what order anybody has things anymore, but okay. I'm gonna make up some stuff because I don't even know if this is true or not. All right, so let's say, oh shit, I'm trying to think of a big name company. Let's say like DreamWorks movie production people, right? Under DreamWorks, you might have MGM Productions, and under MGM Productions, you have Lionsgate, and under Lionsgate, you got Fox News and ABC and CBS. So let's say ABC decides to put out something on their newscast that is illegal, and it how do you say it? Defamation of character, that type of thing, whatever. With a good enough attorney, you get to go all the way up to the top of the food chain to sue that person because these other people, corporations, are up underneath them. Right? Same thing with when you're talking about gang stuff. You have, like, with Mr. Hoover, he was the leader of the gangster disciples. So it didn't matter what set you were from, if you were a gangster disciple, he was responsible for all the activities of all the sets. Now, of course, that's too much for one person to take care of to try to control all these thousands of people. So then he had his generals and his lieutenants and his chiefs, and they were all divvied out, people up underneath them. That's what they're trying to say. Now, let's say we go all the way down to the YN who killed somebody. If the government wants to, and they could connect the dots all the way up the food chain, then they could connect it all the way back up to the head honcho. That's what they're doing with Durk. Because Durk made the mistake, or a cooperator is lying, whichever way you want to look at it. Several cooperators are lying, all telling the same lie, when they all said that Durk said that he would pay money for any GD to be killed. So technically, if they want, they could go down a whole long list of incidences and blame him for that. I believe that the feds have way more evidence than what we're seeing. And I think that's what's scaring the pants off of Drew Findlay. And I think a lot of this evidence may be coming out of Illinois and Georgia. And that's why he's beating the brick so hard to try to have it severed. But you got to remember, you wanted to be the voice. of Chicago. That voice carries a heavy responsibility. You telling everybody what to do. Honestly, that wouldn't surprise me. I've said that from the beginning. Everybody's asking me, you think he's going to get free? You think he's going to get locked up? If history repeats himself, he's going to get a slap on the wrist and he's going to walk away, because that's what's happened every single time to this guy. If evidence wins in the courtroom, then he's going to get locked up for life. I could see BAYZOO not denying something, but I really can't see BAYZOO telling something, if that makes any sense. I think BAYZOO moved himself around. BAYZOO started getting into his faith. A lot more than Durk did, that's for sure. Sometimes. You think Mr. Larry Hoover didn't have money? Now let me ask you this. Why? Let me word this carefully, should I say. If I were to look at the alleged bodies that BAYZOO has, which is Mubu Crump and Big A, I could say, okay, I get where he went after Mubu Crump because he was really trying to go after Melly Yarmel, but he couldn't reach him, and he could only reach Crump, so he got Crump. Why would BAYZOO go after Big A? Unless he was told to, or unless it was important to somebody else that she was taken out. Think about that. Let that sink in. Who had the bigger connection to L.A. Capone? Durk or Zoo? Durk did. But Zoo took out Big A. Those bodies were not connected to Zoo, though, is what I'm saying. Those bodies were connected to Durk as far as being close to him. If you look at the history of a lot of these BDs, even Vaughn, T. Roy, all of them, these guys that had a lot of bodies, very few of the incidences of the cases was on a personal level. Majority of their bodies that they acquired was to impress Durk. Yeah, it is for the police to solve. But I'm just saying, I'm quoting what I believe that the police already know. I don't think, let me see, how do I say this? I think the California investigators are more intelligent than the investigators, or more diligent than the investigators in Chicago. Their disadvantage is they haven't worked Chicago. Well, when you have eyewitnesses and cooperating witnesses, that's where you prove things. And that's what they're saying they have. Do I think Durk pulled the trigger on any of these weapons? No. That's what he always had everybody else doing. That's what he had D-Thing doing. D-Thing even admitted it. There is an old video, I don't know, I want to say it's prior to 2016. It's old. It was like maybe 13 or 14, something like that. He's sitting on a step of a little house with another guy, and there's somebody talking to him. I don't even remember who it is. I don't think it's Zach. I think it's somebody else. And they're asking him about, he just came back from another state. Like, I don't know if it was Michigan or where it was. Came back, he was living in another state up north. And Durk had told him about his music, or he got a copy of Durk's music that Durk had made a song or something like that. So him and his buddy came back to Chicago to help promote Durk. And he says it in that interview. He says, he's the bag. It's my job as his big brother to protect him. And that's what he did. Hey, Lashina. That's what he did. That was his job in his eyes. So anytime somebody was dissing Durk on the internet, whether it was Twitter wars or whatever, D-Thing would always step into that. And I can understand that, because I'm going to do the same thing for my sisters. But you take it a step further when you start pulling guns and shooting people and killing people over words on the internet. And that's what D-Thing did. Hold up. What you saying, nephew? No. Hold on. Somebody else done stole my content. Why do they keep doing this to me? Oh, he took all my shit from the other night.
No, you're not eating. No, you're buying them. Oh, yeah.
Bastard. I don't know him. See, I don't have to go look for it. They come and tell me. Yes, they are. And don't want to even give me credit. Don't even say thank you. Don't even. I had some goofy kid. I'm going to say goofy kid. This might be a middle-aged man sitting in his boxers playing with himself. I don't know. He come up in my DMs the other day. Now it just says Instagram user. So I don't even know what the hell his name is. Said, let's see. This is how he first spoke to me. We had a conversation for one day. Yo, can you give me the Odie Perry full CCTV footage that you posted on YouTube like 2 years ago? Bitch, I don't know you. And then he swore to me, and he starts arguing with me, that Domo and Ming Ming were the killers of Odie Perry. So we're going back and forth, back and forth, and back and forth. And by the end of it, he said, y'all some weird motherfuckers, for real. Your son is a bitch. He ain't never killed nobody. My son? Why? Yeah, I just now noticed that. Because I quit answering the guy. Shut the fuck up. You suck on Butta's dick too much. They ain't nothing but a bunch of some bitches. He's just going all over the board. This is what I gotta deal with. Instagram motherfuckers. Lashina, I enjoyed your live today on Facebook. And I know you said that they don't get under your skin. But moderators, don't kick my ass, because y'all know y'all be on my ass about reacting to people too. But that's what they want. They want a reaction. And a lot of times I give it to them as well. And it truly it bothers me when I see people saying the things that they say about you on here, because thank God I've never lost a child. I've come close, but I never have. I don't know how I would handle that. I really don't. And that's why I commend you. Because can't nobody tell nobody how to grieve. Thank you. For the longest time when I had my original YouTube channel, people would ask me, why do you do this content? I says, because if I can get just one person out there to feel better about their life, feel like they ain't the only one going through some shit, then I feel like I did something good for somebody, even if I never know about it. You made me laugh though. You said that your mama should have swallowed, because I got a friend on Facebook. We've been friends for about 8 years now. She's like 4'10", school teacher in New York in the Bronx. That's a little Tasmanian devil. She used to get on my lives and argue with people. She says, your mama should have swallowed. And then she should have throwed you up and spit you on the ground and stepped on you. And when you said that today about your mama should have swallowed, don't forget to stuff. Throw them back up and spit them out. She said, there was another one that she said something about clear your throat because all your kids are swimming around and it sounds like you're gurgling your kids. Some shit. I'm just saying. Babies. There you go. There you go. There you go. I had a dude one time. He was older than me. He was in a band. Y'all didn't know this about me. He was 6'6". He played in a band. He played bass. And we broke up. And one of my friends so-called friends was trying to get with them. And the story came back to me that they had messed around or whatever. But hey, we were already broke up, whatever. That's the kind of girl you are. Okay, now I got a heads up. That's the way I took it. About a year or so had passed by when I ran into him and we were talking or whatever. And I was cool with it. I had no problem. He was crying because he still wanted to get back with me. And he was like, I says, anyway, you fuck so-and-so, da 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 da. He goes, I rubbed my dick on her thigh. That was it. And God, I was only, I don't know, maybe 19, 20 years old at the time. I don't know how old I was. Well, yeah, it was before I had my first child. So anyway, and I remember thinking, I don't know that I could ever let a man do that. It just feels too much like being a dog. Um, in order for me to get that footage, if there is footage, okay, let me tell you the route I'd have to take. First, I have to get the case file from that homicide, from that shooting. In that case file, if they have footage that was collected, it'll be invoiced. Then I have to do a request for the footage that's invoiced. So I don't even know that there is footage, but it's something that I can check into. I will say this, I've got one of the older guys from Chicago. He requested several months ago actually, for me to do a FOIA request on Dirty Rail. And it took about a month. They sent me a letter that says, we need an extension of time. Now, mind you, by law, within the first 10 days, if they need an extension, they're supposed to ask me within the first 10 days or tell me within the first 10 days. And then they only get a 5-day extension. So that's 15 days. At the end of the 15 days, you're supposed to tell me yes or no type of thing. It's been almost 3 months. I contacted them today and let them know I guess I'm going to have to fill out the request again. The T-Roy footage took me almost 3 years to get. And that was with me doing request after request after request, like every 2 months. Almost 3 years before I finally got it. And right now with the trial of the century going on, they're trying to tie into Chicago, they probably are very nitpicky with what FOIA requests they're allowing that has anything to do with anybody remotely connected to Durk. And Divine can tell you this. She noticed a while back ago, and I had noticed it as well. If you go to even just Chicago's police website thing, where you look up people that's been arrested and what they're arrested for, whatever, a lot of these guys' records are wiped from the internet. A lot. Let me see, D-Love. What you got? Okay, I hear you. Oh, wait a minute. We got some more. Reply. Sealed document, sealed document. Okay. So where'd we leave off? 471. Okay, 472 is missing. 473 and 474 are sealed documents. See, I get notifications all night long. Hold on. We're just not getting 466 in. Audio recording is to defend it. Hold on. Electronically filed documents, audio recording for Grant Wilson Jones. Aha. Looky here. Let me see if I can blow this up. I'm gonna take a screenshot because I don't need people all up in my business. I'm doing this for all the people that says that them other guys are not on the indictment. Grant, Wilson, Jones, Lindsay, Houston, Banks. All right. Hold on, I'll pull it up so y'all can see it. Uh-huh. Uh-huh, uh-huh, uh-huh. Let me grab this other document while I'm here. Y'all give me just a second. Forgetting me to check my email while I'm live. That's how I found that goddamn grand jury subpoena. Scared the hell out of me. Sealed, sealed, sealed. Oh, they're all sealed. Defendant Dirk Banks' reply in support of his motion to sever counts. It's under seal. Seal ordering granting ex parte application to file under seal. Defendant Dirk Banks' ex parte application to file under seal. Under seal. Okay. All right. So let me show y'all that one. Window. There we go. There we go. There we go. Clickety, clickety, click. Clickety, click, 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 click. StreamYard just make it hard now. All right. This is 466, but it just got dropped on the Pacer, but it's dated July the 7th. It says Grant, Wilson, Jones, Lindsay, Houston, Banks. The following errors were found. The hearing held on July the 1st was taken by a court reporter. No audio is available because they had filed asking for the transcripts from the audio. This is a text-only entry. There is no documentation for this. So, that's all 6 guys are still on the indictment. Well, for somebody to say that there's footage of that, they would have to have seen it. They would have to have the case filed to say that there's footage or whatever. I don't know how many more years does Trump have in office. I don't even remember when he got voted in. I don't even know what year this is. Y'all think I'm playing too. That's the funny part. Y'all think I'm playing. How long has Trump been president? Fuck, I'll ask Google. Google will tell me. How long? Google don't have a delay. Has Trump been the president? This time, yeah. This time. Damn. So that means he's got until 29. No, I don't think he can. I don't think he can pardon him because more than likely this trial's going to get bumped back to next year, like it says, right? Then it's going to take a damn near year for the jury selection and then the trial. So we're looking at 28 then. If he's convicted, it'll be January of 2029. Trump will be out the door. And even if he's not out the door, if he's just like almost out the door, the sentencing, God knows how long the sentencing's going to take. You can't pardon somebody that ain't been sentenced yet. That part. My ex has been saying for probably 10 years now, why Trump ain't in jail yet? I don't know. That's your man. You like to watch him. I don't watch the fool. Oh, he irritates me. I can't listen to people that talk stupid. No matter who they are. He better take his ass on somewhere. That's what he needs to do. All right, y'all. It's been almost 2 hours on here. Let me get up off of here. Let me see. Hold on. Hold on, y'all. Y'all got time for something else? Let me turn the sound up so I could hear him speak to me. I'm gonna be talking to her here. She's actually gonna be bringing some food over one of me. So I'll ask her. All right. You ain't supposed to say all that. Hold on, y'all. It should only take about 10-15 minutes. I got something else. I've been dying, but I didn't want to do a whole live just because of it. Oh, answer your phone. You was just texting me. Boy, I know you ain't go to sleep that fast. I ain't gonna talk to you no more then. You call me back, I ain't gonna answer you. I hope you're listening in the bushes. I ain't gonna answer you. Let me see. I really want AK. That's what I want. But he's dealing with some family stuff right now. Oh, I did more than that. Y'all don't pay attention to my whole video. Fine. Let me see. Let me just think. I'm gonna ask y'all a question. And if y'all don't get the answer right, then I'm just gonna end this and be done with it. Royalty, what's up? Let me ask y'all this question. God, I hope there's no delay because I'm impatient with the delays. What was the reason for the O-Block trial? Why was there an O-Block trial? It's not a trick question. It's a very easy answer, I would think. Do 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 do. Ah, na, 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 na. Thank you. Well, that was the long version, but yeah. But what was it that they was guilty of? That's my point, right? Jamal, what's up? No, but the reason for the O Block trial was for the homicide of Carlton Weekly. Period. Thank you, thank you, thank you, thank you, thank you. Now, when did Duck get killed? There you go. There you go. There you go. All right. So, if the trial is about Duck's homicide and Duck does not get killed until August the 4th of 2020, do we need a calendar? I don't think we need a calendar. I think y'all knows the days of the year. Give me a second, because I turned my phone off already, so I ain't gonna see your comments for a minute. This is from the O Block trial. We got Martell Wiley on the stand being cross-examined by Cynthia Gaichetti. She's saying, "You're misunderstanding me. Let me explain what I'm talking about. You remember you had a case in McLean County. You were on probation in a case in McLean County. One of these cases, the convictions, you remember that you had a probation officer, Michelle Lindmeyer." His response, "Michelle Lindmeyer, I ain't got no probation in McLean County." Guy Chetty says, "You never had probation in McLean County?" "No." "All right. I ain't got no probation in McLean County. Like, I don't know who Michelle is." "Okay. Do you remember that on July 28th of 2020, you contacted Agent Doyle stating that you were in trouble with probation, remember?" "Oh, yeah." "Calling them about that." "I was with them, so I had to call there. She was saying that I wasn't with them, but I was with them. I was with Julian and them inside the grand jury when she tried to violate me. So yeah, I was with them. I was with the FBI. I was telling the truth." On July 28th, "I was with them. Yeah, I was with them. I was with them twice when I missed court. I missed court for one court date. I was with them. Yeah, I was with them another time. I missed. Okay. Yeah. Okay. What date?" "What date?" July 28th until August the 4th is how many days? Seven days, or 8, if you count both the start date and the end date as full dates. Let me see. 1, 2, 3, 4, 5, 6, 7. He wasn't dead yet. So how are you making statements to the grand jury because of Carlton Weekly getting killed? Tell me I got fake paperwork again. That's the transcripts from the goddamn O-Block trial. Tell me again, I make up fake paperwork. How is this fake paperwork? You think I've sat here and wrote up 263 pages? All these freaking words? Court adjourned to reconvene on December 5th, 2023 at 9 a.m. I made all that up. You're missing my point. Y'all are missing the point. He could not have been telling about Duck's homicide if Duck had not been killed yet. There was no prior charges even considered before Duck's homicide. Those grand jury hearings were not about Oblockians. And it's not fake paperwork, Maine. Safe to speak. With that being said, thank y'all for tuning in. It's been over 2 hours now. Y'all stay safe. I'm off tomorrow. I don't have to wake up to no alarm tomorrow. No. Why would he need to be telling how the gang operated if there was no indictment yet? The indictment was on the homicide of Carlton Weekly. There was no indictment yet. Take that into consideration. The only thing on that indictment was the homicide of Carlton Weekly. They overshowed their hand. All right, y'all stay safe, and we'll be back. Make sure y'all hit that replay, gang. It's still D-Love. They still have not updated it. I don't know why.